Okay, I think we are good. Good to start, good to kick off today's event. So first of all, a good afternoon to those joining today's ECIPE online webinar. Good evening and good morning to those of you who are joining from overseas today. My name is Matthias Bauer. I'm a director here at ECIPE, and I will be the moderator of today's event, which is about the EU's Digital Markets Act, in short, 3 letters, the DMA. And today we want to address a key question. The question is, what about us? What about us in our capacity as consumers? And we want to discuss a recent study that we did together with EPPP, I shall say, the European Public Policy Partnership, which led in this particular project, and it is about consumer responses to the EU's Digital Markets Act, based on a unique survey of 3,500 consumers in 7 Central and Eastern European countries. The Digital Markets Act, it was introduced with many promises. One promise was to empower consumers, another to enhance privacy, and a third one, which was about the contestability of digital markets in the EU, making digital markets more contestable. Well, 2 years after its implementation, we can begin to assess those promises, how those promises look like in practice. And the picture, to state this right away, is complex and complicated. And I would also argue much more sobering than the original political narrative suggested. When we at ECIPE first examined the DMA proposal back in 2022, it was, our analysis already pointed to several regulatory risks. We warned about conceptual ambiguity, unclear objectives, and legal uncertainty. And back then, we already recommended narrowing the DMA's objectives, clarifying the scope of core platform services, aligning enforcement more closely with established competition law principles, first and foremost, consumer harm. And we also called for meaningful regulatory dialogue to arrive at a regulatory regime that is more predictable and also aligns more with the original objectives when it comes to the enforcement of this new and back then untested regulation. Well, 2 years on, the EU and member states have built a large enforcement apparatus. The European Commission has expanded its staff quite significantly. And national governments have also set up or scaled up their staff, their departments to support the DMA's implementation, but also to support their own competition regulation, focusing on business models operated by large technology companies in the European Union. However, despite this quite substantial bureaucratic buildup, legal uncertainty remains high. Companies continue to face complex and ambiguous obligations, and much of the guidance they need is either missing or contested. And enforcement risks being shaped in the courtroom rather than through clear and predictable regulation, as we've just seen with Apple's submission to a key major European court a couple of days ago. Now, to transition to the key subject of today, consumer impacts from the DMA. To state this right away, the consumer experience actually reflects this reality. Our survey, led by EPPP, is based on questions directed to 3,500 consumers across 7 Central and Eastern European countries. And it shows that the DMA has not delivered clear benefits in terms of affordability, privacy, and choice. Consumers, this is the bottom line, they continue to rely on the platforms they trust, valuing reliability, functionality, but also convenience. And contestability, in a nutshell, it exists more on paper than in everyday practice. And this is what we want to discuss today. Today's event will explore why regulatory goals and consumer realities diverge, and what this means for the future of EU digital policy, and based on the inputs from our speakers, what it potentially should mean for EU digital policy. We are joined today by 3 excellent speakers. So first of all, thank you very much for being here. We have with us today Eric Tedeli. He's a senior analyst at the European Public Policy Partnership, and his work focuses on technology policy, payment services, energy and regulatory developments in the European Union. We have with us today Philip Kuchuma. Philip is the director of the Smart Consumer Institute, and his analytical work centers on consumer impacts across technology, across AI and digital policy, but also financial and housing markets, taxation, retail services, and e-commerce. And last but not least, we have with us today Jacob Hankowski. He is the managing director at Ipsos Slovakia, and here leading the practices that focuses on public opinion measurement work in Slovakia. Each speaker will now start with a short opening statement of around 8 minutes or so. Jacob, our second speaker, will spend a little more time to present to you the findings, the key and major findings of the survey that we did, also using a presentation. But before we turn to Jacob, let's start with Eric. Eric, the floor is yours.
Thank you very much, Matthias, for the introduction, and thanks everyone for joining this webinar. Well, I would like to focus on what led us to conduct this extensive study of the consumer experience. It is actually one of the first comprehensive snapshots under the DMA, focusing on lived realities rather than abstract preferences about big tech or Brussels institutions. As you know, passed in autumn 22 and applicable since spring 23, the Digital Markets Act has been reshaping the way consumers interact with the most popular online platforms for more than 2 years. Next slide, please. Well, what was our main aim? It was to assess the extent to which this landmark legislation has fulfilled the European Commission's stated objectives. That means promoting open and fair digital markets by enhancing consumer choice, strengthening data ownership rights, enabling portability, and facilitating streamlined access and ensuring unbiased search results. But before examining the survey findings in greater detail, which Philip and Jakub will do after me, it is also useful to outline the scope of the DMA regulation and the promises made by the regulators. Next slide, please. So, as you surely all know, the DMA targets large digital platforms designated as gatekeepers due to their market positions and substantial impact. The European Commission has so far designated 7 gatekeepers under DMA. That's Google, Amazon, Apple, ByteDance, Meta, Microsoft, and Booking, which have all in all 23 core platform services that are provided by these gatekeepers and are currently subject to the DMA. The gatekeepers are required to comply with a set of obligations designed to govern their operations. And looking into the main measures they have to comply with, we could name the following ones. So the main DMA measures include ensuring free promotion. That means it requires gatekeepers to allow business users to promote their offers directly to consumers without additional charges. For example, Apple must permit links or buttons in apps for direct purchases outside the App Store, and also allow developers to complete contracts through these alternative channels. Secondly, ensuring access to third-party applications. End users must be able to access and use content or subscriptions through applications provided by business users, even if this means actually bypassing the gatekeeper's own platform. For instance, DMA requires Apple to allow sideloading from third-party sources, that is, enabling users to install apps from sources other than its official App Store. Then the third point, preventing tying of services. So this is the practice where access to one core platform service is made conditional on the use of another. To name a specific example, Microsoft as a gatekeeper through its Windows operating system previously bundled access to Microsoft Teams or OneDrive with Windows, which effectively required users to subscribe to or use these additional services to get the full experience of the operational system. However, under the DMA, Microsoft can't force users to use or subscribe to its other core services as a condition for accessing Windows. The fourth point, self-preferencing. The DMA specifically targets this practice where gatekeepers would favor their own products or services over those of competitors. Commission recently stated in this regard that Google breached this article by giving its own services such as shopping, travel, or finance preferential placement in the search results over equivalent services offered by competitors. The fifth point is ensuring interoperability of digital services. The DMA acknowledges this need for interoperability, particularly for messaging services. Because, for instance, before the DMA, WhatsApp users couldn't message Telegram users, which was reinforcing the platform dominance. However, the DMA now requires gatekeepers' messaging services to provide interfaces for horizontal interoperability. The sixth point, ensuring enforcement and compliance. As you surely know, Commission is empowered to enforce the DMA through a range of measures, opening proceedings, imposing fines of up to 10% of global turnover, and issuing periodic penalty payments. Next slide, please. So now to the promises which were made towards consumers by the European policymakers. This is promoting better and more affordable services, promoting more secure and private services, and having a more contestable market environment, as Matthias mentioned in the beginning. To the first point, more affordable services. By fostering more contestable market, the DMA was actually intended to empower consumers and create conditions that benefit end users directly. The regulation itself was designed to give consumers access to a broader range of services and facilitate switching between these various providers. This would also enable small and emerging businesses to compete effectively alongside the dominant platforms. So at the end of the day, the consumers were supposed to enjoy more affordable and accessible digital services. The European Commission, in its original 2020 impact assessment, actually estimated the consumer surplus of approximately 13 billion euros. The second point is promoting more secure and private services. So the European Commission has placed significant emphasis on enhancing the privacy and rights of consumers in the digital markets, which is reflected in several of the regulation's provisions. Users are granted the ability to freely install or uninstall software applications, modify default settings on core platform services such as search engines, web browsers, or app stores without some undue restrictions or interference. Furthermore, to prevent anti-competitive practices, gatekeepers are not allowed to give preferential treatment to their own products or services in ranking, indexing, recommending, or displaying offerings, as I mentioned already before. So through these measures, the Commission has attempted, in theory, to safeguard the consumer privacy and access to a diverse and competitive digital marketplace. And the last point, the last promise that was made by this regulation was promoting more contestable market environment. So the Commission was committed to strengthening competition, reducing barriers in the digital markets through a range of measures I already outlined before. So this is in a nutshell the promises which were made and the measures taken. And now I would yield the floor to Philip and Jakub, who will focus more on how the European Commission actually achieved these goals 2 years after the introduction of the DMA.
Yeah, thank you very much, Eric. Before we move from promises to reality, allow me one more follow-up question. You mentioned that this is one of the first studies focusing on consumer impacts, or generally speaking, the impacts of the regulation. Are there any other studies that are worthwhile mentioning or that you come across during the research?
Well, so far this was the most practical ones, focused really on hearing the voice of the consumers.
Okay. Yeah, so I think there's one more study quoted in the study that we did, and this one was prepared by a team around Camilo Kenamo. It's about the economic impact of the digital market sector on European businesses and the European economy at large, published in June 2025. But I think you're right. The study that we did is actually the first one looking into consumer benefits, to some extent, of course, also into consumer harm or perceived harm, and how consumers look at the DMA in terms of whether it mitigated harm or not. And that, of course, is very important, given that consumer harm is, or addressing consumer harm is one of the prime motivations that we have in competition policy. Okay, now moving from promises to reality, Jakub, over to you. You have led the survey work on the side of Ipsos.
Thank you very much, Matthias. Good afternoon to you all. Thank you both for introducing the topic. It's a really important context, and what I will be showing now, and I will just use the floor for roughly 15 minutes to introduce the study that has been mentioned and quoted several times already, to give you more detail about the objectives, about how it was done, about what methodology was used, and what are the key outcomes. Of course, within the 15 minutes, we'll really just focus on the high-level interpretation, but I'll be happy to take the questions at the end, as was already announced. So let me start with repeating what was already said, and there was really a missing piece of information around the DMA, and that was an exploration of what is the consumer experience in European countries, in selected European countries at the moment, with a potential effect of the European Union's Digital Markets Act. And what we focused on, it was quite a complex study, and you'll see the complexity of the topics. But the three key areas really were the awareness and satisfaction with the DMA as a regulation, but especially as the changes which they influence or cause across the major platforms from the consumer's point of view. And that we were actually looking at the experience with limited innovation access and their attitudes toward the regulatory trade-offs, and perspectives on privacy and security concerns, because it's very important to look at the let's say the broader trends which influence the discussion and influence the public opinion around these topics, as not every consumer is an expert, and we'll see that from the results. I think that will be quite clear. So how it was done, it was already mentioned, it was done across the 7 countries within the Central and Eastern Europe, 500 sample per country. So we have 3,500 respondents. The samples were aiming at the representativity on the online adult population. So we use the quotas for age, region, gender of the respondents, so that we really covered the online population of the respective countries. And we covered quite a lot of topics. The length of the questionnaire was 15 minutes. This was a standard quantitative study, which took place in the mid of July. Yeah, let's just dive into the outcomes. So to summarize the results and to give you the first hint on what the key outcomes are, is that while the DMA aims at what has already been said for the benefit of consumers, which is an important highlight, our survey indicates a deeply ambivalent and paradoxical public response. And it's worth diving deep into the data and into understanding what is so ambivalent and paradoxical. And first of all, there is a profound deficit in public awareness regarding DMA. So in total, it's about 80% of respondents in some countries, going up to 85% of respondents, who actually have either never heard of the DMA as a regulation, or they possess no substantial knowledge of it. They may have the name, they may have the shortcut, but they don't actually understand what is behind. And on the other hand, when we show the consumers the changes that are related across the major platforms, and we tested a few of them, they have actually noticed the changes. So more half of the consumers have said that, yes, we have noticed those specific changes in the platforms and in the services that we are using. However, a big portion of those people are not sure if that changes are due to the DMA. So that is the first premise we have to work with. There's a very, very low knowledge of the DMA. There is a very low ability to connect the changes that people actually see with the DMA as a regulation. We can see a dual nature of consumer engagement with technology. And let's start with looking at how the services are used. And we see that even in this study, but this has been, of course, measured across a lot of studies quite regularly, and we can see a high frequency usage across all the platforms. So we see 70% of the people actually using Google search multiple times per day. We can see people using Facebook on a daily basis, and that is relevant for other platforms as well. And at the same time, we have a majority of people who are concerned about privacy, and even they are now more concerned about privacy than they were before. And that is connected to a broader trend, which I will talk about in a minute, but it's still a fact, and it's still a fact even in these days, in this context that we're discussing. The regulation itself, as I said, a lot of people do not know the regulation, but still, when we ask the people in this study or in other studies across other regions, even outside of Europe, people are pretty able to agree with the need to regulate technologies and to regulate social media, to regulate digital platforms. We'll see that in detail. So here we see that majority of the people, they prefer stronger regulation, and they even prefer it even if there is a delay access to new features. But at the same time, and that's the regulation paradox that we'll be showing, 40% of those people feel that they now need more steps to complete the tasks that have been previously simpler. And there is a big clash between the declaration and between what they actually, as consumers, expect and prefer in their daily usage of the platforms and of the services. And the same thing applies to the privacy. So we know something called privacy paradox, where on one hand, there is a pretty limited trust in platforms' data protection, and that's not new, and that's not only localized in the countries which we are focusing on. But on the other hand, again, looking at how people are using the platforms, they are, even knowing the risks that they perceive, they are still using and are unwilling to pay subscription fees for those services and use the free services, even with the threat that they themselves subjectively feel that is connected to that. So that is the the key outcome, which we will now look into a little more detail. And let's start with the deficit in public awareness, which I already mentioned. So here you can see across the countries, it's pretty similar. We've got 20% of the people who declare that they know the law somehow, they have heard, they have some partial information. Otherwise, the DMA is generally not known across those countries. And it's interesting when you compare it with the GDPR some years ago. Even a few years after the implementation, there was still around 1/3 of the people who have heard of it but did not know any information. It's just the Digital Markets Act at the moment is not really well known. It's very, very little known across those countries. And when we look at the consumer engagement with technology, and I just use Google search as an example, people are using the technology and the specific service very, very often. Of course, we can see a very high digital platforms usage in the daily life. We can see a very high usage of internet services in general across Europe, and that is proven by many other studies. But when we look at the concern about the privacy and data protection, yes, as we already said, 55% of the people now definitely, or rather, agree that they are more concerned about their privacy and data protection at the moment, which aligns with the global trends, which are actually saying that those people across the world are pretty, say, distrusting in the tech companies' handling of personal data in many, many Western countries, in many countries across Europe and outside of Europe, in the US. But we know that, and we know that from the broader perspective. So Ipsos is doing a multi-country study. It's been around for more than 15 years now. And what we can see at the moment is that there's a big paradox in the perception of technology and digital technology. So 71% of the people now actually agree that we need modern technology to solve future problems. But at the same time, almost 60% of the people think that the technical progress is destroying their lives. And this is actually increasing. So there's a big paradox about understanding that we do need the technology, and people increase of usage of the technology, but at the same time, it's a natural fear of that. When we look at the regulation and regulation paradox, we see that people are, let's say, tending to agree with saying that they do prefer stronger regulations and the transparency of the platforms, even if it means delayed access to new features. So I already mentioned 55% top two box in that, so people who strongly or rather agree. But on the other hand, when we look at how they perceive their daily usage of those services, almost 40% of those people feel that they do need more steps to complete tasks that were simpler before. They are seeing the, say, concrete and specific outcomes and effects on their daily usage of the platforms, which they are using very much. The privacy paradox I was mentioning is connected to people not trusting, and we know the privacy paradox, by the way, from a lot of academic work from the past as well. And we can see that on one hand, there is only a 25 to 30% of people, the users, who express trust in platforms like Facebook or Instagram or others to protect their personal data. But on the other hand, their stated concern does not translate into their willingness to bear the financial costs of their perceived privacy. So here what we can see, and I think this is a very important piece of information, that we have 7% of the sample who says that they dislike this practice that they perceive, but would rather pay a subscription fee for an ad-free experience. It's just 7% of those people. But we've got 2/3 of the sample who say that they do dislike the practice, but at the same time, they're unwilling to pay a fee. So they accept this as a trade-off for free services. To summarize what we just saw, it's really important to bring more and more consumer view and perception into the discussion around any regulation that aims to improve and increase consumers' experience and benefits. And that in response to the changes that the DMA has or was supposed to cause, we needed to understand what the consumer's standpoint is at the moment. And the survey did reveal a central paradox where consumers, on one hand, support the digital regulation in principle. And we saw that across the world. This is a trend. It's a big topic. People do feel that they are more, say, threatened by a privacy risks, especially by the digital companies. But at the same time, they have a very low awareness of the DMA, and at the same time, they're unwilling to pay for the services. So they ultimately prioritize a free, seamless user experience over the very privacy and control that they claim to desire. And while there is a strong public support for the EU's role in regulating big tech and growing concerns for privacy, there is a very low awareness of the specific changes that the DMA has brought. And as I said, consumers are caught between wanting more control and protection, but on the other hand, they want a seamless, simple, free user experience. So they are reluctant to pay for services. That means that, in fact, they are continuing to accept data for service models, even when they express distrust in how the platforms handle their data. And the second and the last point is that this complex and often contradictory, and we might discuss that, and you might have a sense that there's a lot of contradiction, a lot of paradoxes into that. That's a big challenge that presents a major challenge for regulators to actually aim to create a more competitive and secure digital market without negatively impacting the user experience that people have come to value. Because people, in fact, and consumers, in fact, want to have the, say, seamless, simple, and at the end, free user experience. Thank you very much. This is the end of my presentation. I'm going to stop sharing my screen, but I'm happy to take any questions.
Okay, thank you very much, Jacob. Very impressive. The numbers are interesting and revealing in many respects. I think there is a little need for more clarification as concerns the regulation paradox. You mentioned, and this is supported by the numbers pretty clear, 55% of people asked prefer stronger regulation, even if it means delayed access to new features. 40% feel they now need more steps to complete previously simple tasks. A good example, I think, that I typically encounter is searching for directions, hotel, restaurant on Google Maps. You can't simply do this anymore by typing it in on Google Search and then go to Google Maps. Now, does it mean that these 40%, they are still inclined to support the EU's role as a regulator in competition? Or is this something that we cannot derive from the data or the questions that have been addressed to consumers? Because ultimately, I mean, we also need to have a kind of a feedback effect. If I were a regulator, I would be interested in how consumers feel about the policies that I impose on companies. So are these 40% supportive of this particular EU action in the realm of the DMA? Or to add another question, what about other digital policies such as the Digital Services Act, which is much more tangible for consumers, really tackling issues that people are also concerned with, hate speech, child abuse or illegal content? Do you have a reply to this already at this stage?
Yeah, no, absolutely. We need to understand, I think, that the key context within which we can have any further discussion is that just a few people know about the Digital Markets Act. And I would be pretty sure that the same applies to the Digital Services Act, to the DSA, and other regulations. That's what I was saying about the GDPR, which has been around, and has been vocally and let's say shared and discussed so much more, and still a lot of people in those years didn't know much about it. So getting back to the DMA, just a few people know anything about the regulation. So they cannot really assess the effects of the regulation, and they cannot assess whether the regulation is going in the direction that they would actually benefit from. There is a general desire for regulation because there is a general global and European trend of being, let's say, more cautious about the personal data and the privacy as a general topic. But it's from the consumer's point of view, they would like to have both, in fact. And I think that the study shows they would like to have both. They would like to have their data protected on one hand. The regulation is some abstract synonym of that. But on the other hand, they would still focus on having their, let's say, seamless, simple, user-friendly experience when using the services. And they cannot connect those with the DMA, because the fraction of the people who actually declare that they know some more information about DMA is very, very small, and we cannot really rely on that.
Yeah, okay, very good. Just to add on that, I think you are perfectly right. There is a certain appetite for regulation in areas that really concern people, like privacy. We already have privacy regulation with GDPR. I think the e-privacy regulation that has just been put on hold, if I remember correctly. But then we have the DMA. And what we can see these days in terms of outcomes in enforcement is actually in several respects undermining privacy. The European Commission asking Apple to open its App Store to providers that potentially offer unsecure or less secure applications. The same is true for Android, which is an open source operating system, but is facing similar challenges here. So there's a clear trade-off in, what you promise with the regulation, how you enforce it, and what you call for when talking to gatekeeper companies and their core platform services, especially when it comes to app stores. Okay, but enough on that for now. Philip, over to you. Please also feel free to touch upon the privacy paradox and the regulation paradox, which is probably something that we do not only find in the realm of the Digital Markets Act, but also in our regulation, focusing on the behavior of corporations and consumer behavior.
Thank you very much, Matthias. Good morning, good afternoon, good evening, wherever you are. So the Digital Markets Act promised consumers a journey of epic proportions that was supposed to deliver better and more affordable services, which would at the same time be more secure and more private, and would also create a market that is more contestable and open to a wider range of competitors. I will structure my presentation into two parts. Firstly, I'll be talking and building upon what Eric and Jakub have said, and I'll be comparing the data and the real-world experiences we have to these promises that the European Commission and the European Parliament made to the European consumers when the DMA was enacted. And secondly, building upon that, I will outline several recommendations that both come out of the study and are endorsed by an upcoming open letter that is co-signed by organizations from across the CE region, including us here at the Smart Consumer Institute. We have amazing teams from the Czech Republic, from the Consumer Forum, from the Hungarian Association of Consumer Protectors, from the Slovenian Institute for Strategic Solutions, and others who are joining us in very targeted recommendations on how to make protection of consumers online better. So to jump straight in, the Digital Markets Act was supposed to deliver better and more affordable services. However, as Jakub has already outlined, 39% of consumers, so a large and vocal minority of them, report that they now need to complete more steps for previously simple tasks. And approximately 1/3 of consumers report that their digital experience is now less seamless and more confusing than before. And we have specific examples to prove that. In the past, when you put Hotel Madrid into your Google search, you got a nice pop-up window which featured a map, a selection of recommended hotels, but that had to go away with the Digital Markets Act and was instead replaced by a selection of links and advertisements. And what is quite paradoxical about this is that in trying to micromanage every consumer's interaction with the digital environment, we have somehow lost the plot. Because when we look at the results that appear now, I have checked them approximately 20 minutes ago, and this screenshot is still relevant. The first thing you get is a link to booking.com, which is actually one of the designated gatekeepers under the Digital Markets Act. So in trying to provide services that are better and more contestable, we have ended up with something that is for sure less convenient and also doesn't promote new entrants, new competitors. It promotes the entrenched gatekeepers, that is booking.com. And I have nothing against booking.com, it's just the simple truth in the Commission's words that they are a gatekeeper. When we look into other services, this is one of those less seamless examples. Now we have also examples of delayed features, which was, for instance, Meta's Thread app launch or Apple's AI tools. And this is a delay, but then there are also cases where consumers are still unable to enjoy the services that are freely available to consumers in the United States and elsewhere. For instance, iPhone mirroring, where you are able to see things from your iPhone directly on your MacBook, or live translation with AirPods, a feature that was a few months ago unveiled by Apple, still remaining unavailable to European consumers. So, of course, we can argue that this is not cataclysmic, that this is not the end of the world, but when the premise stands at making services better, more seamless, then they are not. Because as you can see here, you could click directly to the maps. Now you cannot. And the second part of the promise was to make the services cheaper. But looking at that, we see that the ways that the companies responded to the Digital Markets Act, for instance, in case of Meta, was to either introduce a paid ad-free subscription, which is not cheaper, or to offer consumers an option of less personalization, but that includes ad breaks that you cannot skip. So all of the DMA-induced solutions do not result in better or more affordable services that are now available. And looking at this, we might say that, okay, it's all acceptable to create this little bit of friction if at the end of the day, we are in terms of trying out other alternatives, looking for other options. But then when we look into the second promise that Eric already outlined, that is promoting more contestable market environment, we see that people remain stuck or people continue to use the options they had in the past. 70% of people, as Jakub has said, use Google search multiple times a day. And strikingly, roughly a half of consumers use no alternative to Google. And when we look at other research that was done on Google's changes, for instance, the search and the inability to click directly from the search results to Google Maps, we see that consumers continued to rely on Google Maps, albeit with a bit of added friction that they had to put it manually into the search, but they continued to rely on Google Maps. So that is when it comes to promoting more contestable market environment. And thirdly, when it comes to protecting and promoting more secure and private services. In this case, Jakub has already said that on one hand, consumers desire or claim to desire more protection or more security, but on the other hand, when it comes to real-world decisions, only 7% of them are willing to pay for an ad-free experience. And 60 through 69% admit that they accept pervasive data collection in exchange for free services. So, to summarize, when we look at how consumers experience online services or services provided by gatekeepers now, we cannot certainly say that they are better, that they are more accessible, or that they would be in any case cheaper. In some cases, we might also argue that, and we see that in our everyday case, in our everyday lives, that actually some of these steps, such as allowing consumers to download apps directly from the internet to their mobile phones without going through the app stores, leads to more security risks and not more secure services. And when we look at our suggestions based on what Jakub has said, based on what Eric has already outlined, and so the study results, it's okay to try exotic flavors of ice cream once in a while, but when you see and realize that they are not working for you, it's time to go vanilla. It's time to return back to the basics and focus on the good, boring stuff, because boring stuff is boring, but oftentimes it's more effective. And instead of trying to micromanage every single interactions that consumers have with the internet, which just leads to paradoxical outcomes, such as destroying the quality of services only to promote gatekeepers, we should focus on either retorting back to the case-by-case enforcement of specific instances where we see evidence that a competitor or the market player is not playing a fair game. And this would remove blanket rules that assume harm before it occurs. And it would also prevent rushed compliance measures that degrade quality of services without actually achieving real-world market outcomes. And then if our goal is not to scrap the DMA regulation as a whole, but to make targeted changes, we, along with other organizations from the regions and the study authors, ECIPE and EPPP, suggest targeted reforms. So obligations that do not enhance consumer welfare and deliver real-world market outcomes should be repealed or suspended. So, for instance, when we talk about interoperability requirements, marketplace access rules, prohibitions of self-preferencing, we believe that they should be enforced only where robust safeguards exist for privacy, cybersecurity, product integrity, and liability. In practice, and we have already talked about that, self-preferencing removed integrated features valued by customers without delivering substantial benefit to competition. And all in all of these approaches would, in our opinion, show that digital regulation can be focused on what truly matters: affordable services, seamless functionality, strong safety, and genuine competitive choice. Thank you very much.
Well, thank you very much, Philip. That was a very, very rich intervention, referring to what Eric has said at the very beginning with regard to the overall ambitions and promises of those advocating the DMA, designing the DMA on the side of the Commission primarily, but also the Parliament and the Council, but also referring to the key findings of the survey, focusing on consumer benefits. Now, allow me one more follow-up question. There's also a question I would like you to address. Jacob, and also you, Eric. I mean, I think one of the most striking findings in the survey is how little consumer behavior has actually changed. So what do you think reliance on gatekeeper companies, can be Google, can be Meta, can be Apple, and others, why does it remain so persistent? And why does it remain so persistent despite regulatory efforts to open up markets under the DMA? So what comes to mind is network effects, everything that is about network effects, scale, international reach, cost, functionality. So what does it entail from your perspective, Philip?
So we have one great specific example. As a result of the Digital Markets Act, Apple was forced to open up its closed ecosystem and allow competing app stores to exist within the iPhone ecosystem. But the Ipsos study found that awareness about this is actually very low, and most users, over 60%, actually didn't even notice Apple's changes during the survey period. So it's one thing to put a measure in place, but then when we talk about the wider awareness, the competitors who have these alternative services, in this case, maybe haven't done good enough marketing job to promote what they have to offer, or the consumers themselves acknowledge the security risks that are often connected with sideloading apps from unknown sources. In Slovakia, we have recently had very good media awareness campaigns to highlight how fraudsters contact you by phone. They claim to be from a crypto company or from a bank. They prompt you to download some random app from the internet, and then they wipe out your entire bank account. So this is one case where we see that the Digital Markets Act has functioned in a certain way, and that's a specific example from my side.
Jacob?
Yeah, and I would just say it very simply that, you know, the user experience is the king. So the consumers stick with the platforms they know and trust. They make their own decisions, and the regulation alone cannot make them change their habits. Like, no one was forced to start using iPhone or using Google Maps. It's simply that these services provided a better user experience. They were more convenient, affordable, feature-rich. So it is unrealistic that now, like from one day to another, the regulation will reshape consumer preferences and market dynamics.
No, absolutely, I agree with that, and we need to understand that the consumers are very fragmented in terms of using the digital services. So there are some services that are being heavily used, like Google search, for example, but most people are not using the full scale of services. They're not using it that often, and they just stick to what they're used to. But I would like to, let's say, spot some light on another perspective, and that's the privacy and the security, because although we showed that there is still a big distrust in handling of the personal data in the big tech platforms, but there's even much lower trust in the alternative companies that they do not know. And as Philip said, there are a lot of fraud attempts. There is a lot of it has a lot of tension in the media, in the public sphere, and it's something that is influencing the public opinion. And we know in general how much the media space and the public discourse and influencing the public opinion and the position of the individuals. So yes, people are in fact quite loyal. I think that especially the generative AI and the new players that became big quite quickly might disrupt this environment, are disrupting this environment. But we're again talking about the big companies that are global, that will be widely used and are already widely used, which can disrupt the very strong position of Google, for example, in the search environment. But not really the small players who are not that much challenging. And that yes, consumers are very loyal, and they are This is an environment with a lot of distrust in general, but at the same time, people are just heavily dependent on these services because they became a part of their lives, part of our lives.
Yeah, I mean, it's a very good point when we talk about trust and distrust. I think we should always put one word before it. It's relative trust, relative distrust. And I think this is also very often misunderstood or misrepresented in the debate about digital policy making here in Brussels and also elsewhere. It's in the ultimate interest of companies, including the largest technology companies, to do as much as they can to safeguard users' privacy, to safeguard users' how users enact the safety of the service that they enjoy, etc. And I would assume that some users, some customers, they have either a lack of awareness of the regulation, but also, let's say, a lack of awareness as concerns the safety or security risks. But ultimately, most of them do a certain cost-benefit analysis and ultimately go for the service that suits them best. And by the way, there was a competition commissioner almost 2 decades ago, Mario Monti, who served as a competition commissioner at the end of the 1990s, beginning of the 2000s, who said the ultimate test for competition policy, and I would assume that back then he referred to EU competition policy, the ultimate test of competition policy is the benefit it delivers to consumers. So my first bottom line is that the impacts on consumers should actually be taken into consideration by all those who are in the business of competition policy, not only on the side of the regulators, but also on the side of legal advisors. That said, let's now move to our audience. And dear audience, we still have a little time to collect some questions. I can already see 2 questions in the chat. If there are any more questions, please put them in the chat box and we can refer to them in a minute. There's one question from Thomas Beretta. He's asking, do you think the survey outcome would be different if more countries or older EU member states were included? I think he's also referring to, let's say, the Western part of the Western Hemisphere part of the European Union.
Yes, I'll have a quick answer. We're not sure, of course. We cannot be very confident in what the outcomes would be in other countries, but there are a lot of trends that we know are pretty universal. And as we were triangulating the results with other studies which took place in other parts of the world, or especially other parts of the European Union, I have quoted a few. I was mentioning the results from the Western countries or the Western European countries, and the global trends are, let's say, pretty consistent across Europe, especially those about the privacy and data protection.
Mm-hmm. Eric, Philip, do you want to come in too?
I think maybe in the Western EU there would be more focus on privacy, but I still think that the consumers everywhere in Europe want to have these services available in the best quality and have access to innovative services, first of all.
Okay, Philippe?
I would expect, of course, this is just a wild guess, but I would expect that the survey results would be similar across the European Union.
Okay, and one more question. Alternative search platforms, alternative to Google, are most driven by the Czech Republic with a strong position of Seznam, which is quite unique in the EU space and has had its position for many years. I think this is a question that
there was a comment by me, actually.
Yeah, there was already a comment. Okay, could you please elaborate on it? I think there's a similar example, not necessarily related to core platform services, but it's about online intermediation services, in which Amazon naturally is a very strong player in the EU. It's Allegro in Poland. So they are also quite unique in the sense that they capture quite a high market share in Poland.
Yeah. The fact was that I was just reacting to Philip showing that the alternative services in the search sphere are not that frequent, and the fact is that behind those data that Philip showed is even the Czech Republic, which have the historical strong position of Seznam. So those results, if we didn't do that in the Czech Republic, let's say, where it's not really about the new players coming into those environment and taking over Google in the search area, those numbers would even be lower. So yeah, really, it was just to prove the point that there are a few countries which just have some historical strong players in the search area, but we are not really seeing the new players being, well, a part of course of the generative AI, which might be threatening that in the future, but not now, and definitely not due to the DMA effects.
Okay, thank you, Jacob. Are there any further questions from the audience? So I don't see any more in the chat. So maybe a last question to you on the panel. It would be about your wish list. Philip, you've been quite clear about policy recommendation, either repeal the DMA or at the very least, given that we have some institutional legacy now, the EU and the member states, they are bureaucratically invested in it. So the chances that it will disappear are fairly low, I would assume, unless there is, quite substantial amount of political willingness to go ahead with it. But what would be your wish list? What can we learn from the experience of Central and Eastern European countries, for which we now have very good data that might inform DMA enforcement, DMA reform, but also the EU's broader digital policy agenda, starting with you, Eric?
Well, the wish list would be actually that also these data would kickstart a debate also in the member states, on the EU level, on how to approach the digital regulation in the future. I see the question in the chat if it's not too early to assess the failure of the DMA. This study and these data, should provide, I would say, a platform for the further debate, and we can see it in a number of European policies, be it on the Green Deal, on the emission trading system, that member states are starting to question if we shouldn't take a step back and maybe revise the previously adopted policies and make Europe competitive again. If I can put it in this way. So my wish is that the regulators will take this data and discuss them further with the policymakers in the EU.
Thank you. Philip?
I would like to end this on my part with a question for everyone here. The DMA has promised consumers better and more affordable products. But are you're paying the same when you have to the product features that are delayed, that are not available at all? Services and products for European consumers are not cheaper and they are not better. It's time that, as Eric said, we take a step back and evaluate things as they are, so we do not lose the plot in the future.
Okay, and finally, over to you, Jacob. Also, please use this opportunity to promote the work that you and your company do, focusing on consumers, consumer behavior, and consumer reactions to EU policy.
Okay, thank you. So yes, I mean, I think it's quite clear that I'm a researcher and that's my job, and my wish would actually be to put more focus, because we put some light on the consumers' expectations and the effects on the consumers. But as we show, the consumers' attitudes are very complex, contradictory somehow, and they change as the market changes, as the situation changes. So I think that the one-time study is really not enough, and even the regulator should really look at the consumers from the research point of view, to look at the user experience, to look at the expectations, at the drivers of their behavior, and to really ensure that the policies are focused on the consumer, and even the metrics should be more about the consumer empowerment, that actually make sure and track whether the consumers are using the benefits and are feeling the benefits of the regulation. So whether they are using the new choices, whether they perceived level of control over their digital environment has increased, and that should be the outcome. It should be measurable, and it should be measured at the end.
Okay, Jacob, many thanks. I would also like to thank all our speakers and the audience for making time to join our event today. We have more empirical evidence now about the economic impacts of the Digital Markets Act, especially more about the impacts on consumers in a large part of the European Union. If I were to raise a wish, make a wish, I would call for more studies like these to really assess what is going on the ground in terms of how users feel about EU regulations, how aware they are about the design and state of implementation of a regulation, the state of enforcement of a regulation, and what it actually means for how they can use and access certain products, but also digital services, which are the keys, which have been the key subject of today's debate. I think as concerns the DMA, Europe has now two choices broadly outlined in the study. I will return to targeted case-by-case competition enforcement, which is by default focusing more on the consumer, more in the US, consumer benefit or consumer, how the consumer impacts, how the regulation impacts consumer. It's much more rooted in or embedded in antitrust enforcement in the US, not that much in the EU, but also still a key principle underpinning EU competition enforcement. So ideally, and this is what I would also personally subscribe to, go back to targeted case-by-case competition enforcement, or at the very least reform the DMA and reconsider obligations on large technology companies and their platform operations that are vague, ambiguous, or overly restrictive, creating legal uncertainty, do not really help consumers or address consumers' biggest concerns. That, by the way, I do see more on the side of the Digital Services Act than on the side of the Digital Markets Act. So ultimately, it also boils down on where the European Union and member states set their policy priorities in the future. Ultimately, and I already quoted Mario Monti, regulation must reflect how consumers actually behave, the more so in the area of competition policy, and not just how policymakers in Brussels hope they will also take into account their desire to build up legitimacy in Europe for the activities that they engage in. So that all said, I would like to express my sincere thanks again to you, Eric, Philip, and Jacob for your insights. And I would also like to thank everyone else for participating in today's event. We will share the recording of the study shortly, so you will find it on our website, but also on our YouTube channel. And I very much hope that today's conversation will help to shape a more evidence-driven debate about the future of EU competition, regulation, but also EU digital policy at large. So thank you very much.
Thank you.